Yes.
My lords, my lady, I have the pleasure of appearing today on behalf of the Appellant, the Airport Authority, together with Janet Fountain, who was the junior counsel. She sat behind me, the junior counsel who appeared at both levels of the hearing in the proceedings below. My learned friend, Ms. Deal, appears on behalf of the Respondent and sat alongside her as a colleague from her chambers, who's here to take a note of the proceedings.
Very good.
Ms. Deal. The committee has hopefully had the benefit of an opportunity to read the Appellant's and the Respondent's case. They are both 17 pages, which I think is relatively modest, and they are concise documents.
All the better for that, Mr. Houseman.
And I assume also, and have assumed also, unless told otherwise, that that had carried with it an opportunity to do some of the essential reading, of which there's relatively little, it has to be said, in this case, because it's not a documents-heavy case.
Yes, we did think that probably the time indented for was reasonably generous, and that you would probably be able to be a lot more economical than that.
Very well. We had divided the time up equally between ourselves, but
yes, quite.
With that indication in mind, and maybe some judicial tailwind, not headwind, if you'll pardon the aviation metaphor, we will press on. I was slated to sit down by 12:15 to allow my learned friend to start her address, but I'll do my best to get ahead of time.
Good.
With that in mind, I was going to start by just making a single observation, if I may, and that is this, that this appeal at its heart raises an interesting and important issue of law. Of course, you will often hear appellants saying that in this capacity, but this one does. It is not appeal against primary fact or concurrent fact, as my learned friend seeks to characterize it for obvious forensic reasons. The point of law at the heart of this case is the interesting and important point of law which concerns the interplay between common law negligence on the one hand and statutory obligations, commercial contractual frameworks, and indeed the law, to some extent, the law of property and possession and bailment on the other hand. Because what occurred in this case below, at first instance and then upheld, we say, in rather swift and thin terms, if I can put it like that, on the part of the Court of Appeal of Bahamas, was that a common law duty of care was imposed upon a statutory public service authority in circumstances where it exists as a creature of statute, its relevant operational responsibility, i.e. airport security, was defined by statute. There was a claim for breach of that statute, which was dismissed summarily at the outset of trial. There was also a persisting contractual arrangement of some sort between these parties, not sought to be sued upon. And also, there are hints in the way the case was put, if not pleaded, of there being effectively a bailment relationship between these parties, with references to the property of the plaintiff being in the control and custody, as it were, of the defendant.
But did your clients plead that they were in some different position because they were in as a public authority?
They pleaded. I was going to look at the pleading just to show what it was about and not about. But the pleading was to the case as pleaded against my client, if I can put it like that.
Yes, but of course, if you're going to raise a defence, you can't confine yourself to a mere reaction to the pleaded case against you, can you? You need to put the claimant on notice of any special defence that you intend to canvass, don't you?
Well, in circumstances where a claimant, we look at the pleading in one moment, and obviously that engages local rules of pleading, and I don't think either side is taking pleading points. There's a hint in my learned friend's written case of a pleading point being taken against me on the so-called unknown thief finding, but we'll wait to see whether the unknown thief finding really matters at the end of the day.
It's not really a pleading point, it's a substantive point, because if you're going to say the statutory authority is in a different position, there has to be a factual basis for it, and a factual basis would obviously have to have been pleaded.
Well, we will look at that and see how that plays out. So, I was going to start.
very precise contractual provision as to the incidence of the risk or the apportionment of the risk of something happening to the article in that place. And it just seems extraordinary that there isn't in relation to an aircraft.
Yes, that was my reaction too, my lord. We will look at this. It's never been pleaded as a contract.
No, I know.
But in my submission, it's telling that it wasn't, because
Yeah.
if there was any conviction on the side of the plaintiff, any legal conviction, that is to say, that it had contractual rights and there'd been an allocation of responsibility for this sort of security under the contract, we would have heard about it, and that's the obvious and primary remedy they would have pursued. Likewise, under the statute, which was raised and dropped.
But nor was there anything like you leave it there at your own risk type of clause, which is what is almost universal in this sort of in a comparable situation.
No, what we do know in that regard, if it assists the matrix, is that as a commercial airline operator, this plaintiff would have been required to have, and in fact we know did have, its own insurance policy, and therefore as between airport operator, statutory airport operator, and airline owner, we know that the latter had its own private means of redress. Indeed, one of the heads of claim, which was successful below and in the Court of Appeal, is for the increase in premiums under that policy. So in a sense, we have something of a legal irony there, that it is the insured party that has responsibility to look after its property, and yet claims for the cost of that insurance as part of its...
Public authority would carry heavy insurance as well.
It may for certain things, so that's uninvestigated at this point. The pleadings, most of the documents I'm going to show you, I have to say, such as they are in the first bundle, volume 1. And my plan was to go through those that matter, and then look at the law, and then in a sense wrap up on the grounds of appeal. If we can look at the pleadings such as they are, I think we get to that in tab 10, and that's the re-amended statement of claim.
Can you give me some electronic page?
Yes, sorry, my lord, it's 103.
Yep.
And so you see the usual rehearsals as to who the parties are, the plaintiff and the defendant, and then the theft. There's an allegation in paragraph 4 that the aircraft was left in the secure supervision of the defendants. That's an allegation which is denied, which we'll look at in a moment. Over the page, you see the claim for both negligence and breach of statutory duty, and the allegation that the theft was taken by person or persons unknown to the plaintiff. And there's an allegation then of awareness. In 6, 7 and 8 are, in a sense, the follow-up to the theft. And we know the plane was taken and found in Venezuela. And we will look briefly at the evidence of the Mr. Terreros. You'll have picked up on this in the papers. Mr. Terreros, who's one of the pilots employed by Western Air, also turned up in Venezuela. And then there's the plea in 9. The defendant, its servants and agents owed the statutory duty of care to ensure the safety of the aircraft. At that point in time, there seems to be a fusion, at least in the way the case is pleaded, between the two separate torts of common law negligence and breach of statutory duty. But then you see them separated again in 10. Negligently and in breach of its statutory duty, the defendant, servants, agents allowed the aircraft to be stolen, etc. You then have a series of, I think it runs to 8 particulars of breach of statutory duty stroke negligence. So these are coterminous allegations in terms of the facts which support them. They run over the page onto 106, because in my bundle copy, 105 is just a duplication of 104. The allegations which seem to have become the focus of attention at trial more than others are 2, so 10, small 2, and 5. And 8, I think, and possibly also 6. You then have the wrap-up allegation underneath that of causation, the 3 heads of loss claimed, and as my lords and ladies appreciate, the big head of loss was dismissed at trial. The cross-appeal against that was dismissed, and permission to cross-appeal to this committee was also rejected, so that one's gone. The 2 smaller claims, although item 2 there should actually be $750,000 because it's actually 5 lots of 150, totaling 750. That and item 4 as it's numbered, but it's actually head 3 of loss, were both allowed, making a total award at trial of $833 odd thousand. And then interestingly, if you look at the prayer, you'll see that the first prayer for relief is damages for breach of statutory duty, and the second is damages for negligence, for what it's worth. The defence to that is into the next tab, so that's 109 in the bundle. And if we can pick that up at paragraph 4, as I alluded earlier to the fact that there was a denial, you see that in the third line of paragraph 4, except the allegation that the said aircraft was left in the secured supervision of the defendant, which is denying. So there was a positive denial, if I can put it like that, of the allegation of it being the aircraft being left in the secure supervision of the airport authority. There's a specific denial in 5 of any breach of any of the duties under the Act. If we jump down to 9, there's a denial of the owing of a statutory duty to ensure safety of the aircraft, and a positive averment in the final sentence of 9 that the plaintiff, as aircraft owner, is liable to secure the safety of the said aircraft. And then over the page in 111, we see the denial of negligence in paragraph 10. That was the particulars paragraph that we looked at. And then you see the numbered rebuttals or responses to the 8 subparagraphs of that.
So neither party has referred to any specific express provision of the Airports Act. And there isn't any, is there? It's simply an obligation to keep a security department.
It is, yes. Yes, I mean, in maybe a different civil procedure context, there may have been what we call an RFI as to the allegation of breach of statutory duty. The way it played out here is it was flushed out at or before trial, as I understand it. And we'll have a very quick look when we get to the judgment as to how that was dealt with.
And there's no allegation in the defence of a contractual allocation of risk?
There isn't. But on the other hand, there is there's no claim under for breach of contract.
No.
But I take that point. Nor any claim for embailment, for example, despite the allegations of control. I was next going to show you the relevant statute, and then also briefly the security programmes which form part of the rubric of regulation, if I can put it like that. The relevant statute is in Authorities Bundle 1, so that's Record Bundle 6. And it's the 2000 Act, which starts at page 1063. And I have obviously made reference to this in the appellant's case, so we can take this relatively briefly. In Section 1, the Act can be cited as the Airport Authority Act, and Section 3 is the operative provision, as it were, headed Establishment of Authority, whereby this entity was created. You see then what you might expect in sections 4 and 5, which is in a sense, the embodiment as part of that creation or establishment of the authority. Section 6 is potentially important because it outlines what the functions of the authority are. And again, they are in a sense in accordance with common sense, what you would expect an airport authority to be there to do. There is in 6.1c one of the functions. This is not a statutory obligation in a sense, but it's probably...
Sorry, which tab are we on?
We are still in tab 1, but there's more than one statute, my lord, in tab 1. There's an earlier act.
Oh.
Yes, sorry about that. That's why I gave you the page reference of 1063.
I see, sorry.
I do apologise.
We're now on section 6 on 1064.
We are.
Thank you.
And it's certainly okay to pick it up there. This is a description of the functions of the authority, and 6.1c obviously includes one of its functions being the provision of airport security. It is important in my submission to pause for a moment on the word security and the concept of airport security, because it's tempting always in cases when you come to the dispute and you're looking at an appeal on a dispute to think of a word like security in this particular context as what we're talking about here, securing an aircraft operator's property when it's parked in the airport overnight. Obviously, airport security is a much broader concept than that. It is about ensuring the integrity and operational security of the airport as part of an international air travel system. And we all know from recent and relative recent history what the real threats and real importance of that is.
But does the concept include providing security for aircraft?
Well, it includes providing security to restrict access to the airside zone. Yes, my lord, it does. And indeed, perimeter security to restrict access to the airport by people who should not be there.
Inter alia, for the purpose of ensuring that aircraft are not interfered with or not stolen, or you accept that?
Yes, as part of the rationale for it. But I was simply just warning against the temptation to see it as only that or primarily that, because that's why we are here. But it goes much broader than that. So to take my Lord Kerr's example, there could be tampering. There could just be someone who, for whatever reason, chooses to tamper with an airplane.
Fine.
And we'll look at some of the regulations that govern access to and security of the particular aircraft in a moment.
This isn't a Gorison Scott type of case where the purpose of the security is completely divorced from the loss which occurs.
It's not completely divorced, no. I would not contend for that. Not completely. But it's a specific aspect, and in my submission, when looked at in the whole, a small aspect of it, given the insurance position and the commercial arrangements for parking property on someone else's premises.
But you don't know whether somebody who's coming in who is unknown is going to take possession of property which is not his, or whether he's going to do some other damage.
No, he or she may come in and try to steal baggage, or try to pretend, for whatever reason, pretend that they belong to the airport in some way.
Or lay some trap for the passengers.
Or much worse, yes.
Yeah.
Yes, there's a whole range of things.
Absolutely.
Yes.
So securing the premises and making sure that only known and authorised personnel is important.
Yes, but there is something different in a sense about damage to or theft of a commercial airline, and it comes back to the commercial relationship between entities. So if there are all these rationales, or this broad rationale for security, for preserving the integrity of an airport, for all the reasons that security matter, when you're looking at it in our particular instance, you can't lose sight of the fact that you have, at the end of the day, it's commercial property belonging to a commercial entity that's got its insurance in place, that could bargain for protection.
I don't really understand the logic, because if you buy insurance, you have to pay a premium. And if the premium has to cover the risk that a person who happens to have possession of it on the ground is negligent, it's going to be higher, so that the cost to the person using the services of the commercial airline is going to be higher. So it's then who is going to bear the cost of the risk being insured. It's not just a question of insurance being available to commercial airline owner. Also, insurance is available to everybody in this situation. It's not as if it's not available to a person running a
No, it's not available in every context for which security matters, was the only point that I was addressing. So airport security is there for, like I say, a whole host of reasons, good reasons, some of which do not concern damage to or theft of property, or indeed bodily injury to people, and therefore some of which are not the subject matter, or the appropriate insurable subject matter of policies of insurance.
I don't at the moment understand why the fact that you have to have insurance against theft makes any difference. In the ordinary case, wouldn't the insurer be subrogated to the airline, the aircraft owner's case, and be able to claim the total loss back from the airport authority if ultimately the responsibility lay with the airport authority? I mean, I know it didn't happen in this case, at least I assume it didn't happen in this case, and at the moment I don't really understand why not, but why is insurance, I mean, bearing in mind that's the ordinary situation in relation to insurance, why is insurance relevant at all?
It may be that the multiple references to insurance we've had in the last 5 minutes have elevated its conceptual importance in this debate. I think I make 2 references to it in the appellant's case.
But if this is a risk, then the owner of the airport can protect itself by having a contract which limits liability, subject to international conventions. And you're going to show us what the Chicago Convention may say. But provided that if it does have a risk, it knows what to do.
It can do, or it may take the view, and we're delving here into speculation and subjective states of mind, it may take the view that the statute is the framework that matters, and the statute protects it, because the statute does not confer, we'll look at this in due course, the statute does not confer, well, it does not impose duties of the kind which are said to have been broken here. It imposes what we would call structural or supervisory duties. So you do your bit when you create your department and you employ your security officers, and there is no provision in the statute, and it's not capable of being read as imposing a private law claim for breach of those duties.
Forgive me, I wouldn't have thought it was a subjective matter. It's an objective matter, what could reasonably be deduced from the Act, and there's nothing expressed in the Act which deals with liabilities for property of people.
No, but I don't think it lies in the respondent's mouth now to say that this Act confers a privately actionable cause of action that matters for today's purposes, because it did bring a claim and it was either dropped or dismissed. It's hard to tell. So that's gone. Plus, I think on any reading of this statute, it would be intolerable to construe it as conferring a private law claim for damages for breach of the statutory duties that it does impose. It's just not there. And that is telling when we come to what I say is the proper legal approach in this case, Stoven and Wise and Gorringe, which we'll look at in due course. Section 7, just so we have in mind, imposes, or rather deals with powers, and in a sense is coupled with Section 6, because these are the powers that are conferred upon the authority in order to carry out its functions, which are defined in Section 6. I think we can then safely jump to Section 21. And you've seen my overview analysis of this in the appellant's case, and I detect from some of the comments or questions that has been taken on board. The only obligation or obligations on the airport authority are found in sections 21(1), 2 and 5. And they are what I've called, and this isn't a term of art, it's just a descriptive label, what I've called structural obligations. It has an obligation as this statutory authority to create a department, security department, which is supervised by a director of security. That's 21(1). 21(2) to appoint and employ security officers, and in 21(5) to control the security department. Those are the obligations. That's the end of it. And the one which was sought to be invoked in the claim for breach of statutory duty once it was flushed out at trial was 21(1). But of course that was not pressed with any vigour and was dismissed summarily, because it could not be said that this authority was in breach of its obligation under section 21(1), because it did create a department. And there is nothing, if you read on, to indicate, and we would say that therefore contraindicates the availability of a private law claim for breach of that statutory obligation. And when we come to look at some of the case law in due course, by analogy always, to road safety and road conditions in the case of Stoven and Wise and Gorringe, we will see that when the statutory obligation in question is broad and wide, deliberately so on the part of the legislature, that very strongly contraindicates the imposition of a common law duty of care on the part of the statutory obligee, if I could put it. Could we go next briefly to the regulatory rubric, and that we can take quickly. If we go to Bundle 2, Volume 2, tab 41, and that is page 390.
The record 2, not authorities 2.
Yes, sorry, my lord. Record 2.
Page again?
390, my lord.
Okay.
This is an extract from, this is an extract exhibited to Mr. Milo Butler III's witness statement, which we don't need to look at right now. It's an extract from the National Civil Aviation Security Programme, the NCASP, as I've called it in the case, in the written case. It's dated 2000 and it was in force at the relevant time, because this incident occurred, as we know, in April 2007. And this is the product of, or reflects, the government of the Bahamas obligations under the Chicago Convention, and in particular Annex 17, which concerns security, and you've seen a reference to that, but we don't need to look at that. If I can just ask the committee to go to page 414. But to give it context, we should perhaps look at 409, where you have section 4 starting, allocation of responsibilities. You then have a series of headings, and I was running that through to 4.6 on page 414, and that's the heading that says airline operators. And if I can just ask the committee to read 4.6.1 and 4.6.2, which goes over the page. The bullet points have faded in the top half of page 415, but my understanding is that there's a series of bullet points, 7 in total, unnumbered, and finishing with the one above small d, and that, as it happens, is the one that I was going to draw your attention to, because that says control of access to and securing of parked aircraft. And so what 4.6.1 and 4.6.2 C final bullet point are saying is that every airline operator has an obligation to produce its own program, which will be filed with the DCA, that's the Department for Civil Aviation. We sometimes see that rendered as CAD, as the Civil Aviation Department, but it's the same thing. So with the relevant government department, their own security program, which will contain, at a minimum, all of the things then listed in A, B, and C, and that includes specific security measures in C, governing control of, access to, or securing of parked aircraft. That is the National Civil Aviation Security Program for the Bahamas in force at the time. Now, there was evidence at trial, we don't necessarily need to go to this in the transcripts, where Rex Roll, who's, my understanding, is the Chief Executive Officer or General Manager of Western Air, he gave evidence on behalf of the plaintiff, gave evidence in cross-examination to the effect that Western Air never filed one of these.
Sorry,
It didn't get round to filing. It didn't have one at the relevant time. There was a bit of to and fro in cross-examination as to why, and it seemed to turn, in his mind at any rate, on the time when they started conducting international flights. And therefore, he said at the time of this incident, they hadn't filed their program. But in a sense, that's by the by, because the regulatory framework assumes, and indeed requires, all airline operators to have a program in place which that includes that specific provision. I was going to then show you the...
but that only applies if they're providing an international service to them.
Yes.
Yeah.
I'm then going to show you the airport-specific security program, which sits below the National Civil Aviation Security Program. We refer to this in the written case as the AASP. And that we find in record volume 3.2, tab 91, and it starts at bundle page 630, or technically at 629, where you see the cover page. But on 629, we see the Airport Authority Security Programme, 2000. It actually bears a date of September the 11th, 2000. 1 year before 9/11, by coincidence. You then have the contents, which start at page 633. I had drawn attention in the written case to Section 3, Part 3, Allocation of Responsibilities. That starts at page 645. And at 646, you have heading Part 3, Allocation of Responsibilities, and then you have a series of headings. This first one is the Airport Authority, then the General Manager. 3.4, you have Director of Security. I'm just showing you the headings for now. 3.5 is Security Officers. The police, the Royal Bahamas Police Force, are in 3.7. And then various other entities, including, for example, in 311 and 312, the US States Customs and United States. I had referred in the appellant's case to 3.15, and I would like to take the committee to that now. That's at page 651. That's headed Airline Operators. So this is all under the rubric of division of responsibilities or allocation of responsibilities. It says all airline operators are responsible for, and then you have A through to G, and B is the security of their aircraft, and D is controlling air carrier facilities and operation areas to prevent or deter unauthorized access to such areas and aircraft. So it's an express responsibility for securing their own aircraft and controlling access to their aircraft. Section 7, to which there was reference.
So how does that mesh with the obligations of the airport?
Well, buried within that question, in a sense, there's more than one question, because my Lord is asking me about the statutory obligations of the airport found in Section 21, as I understand it. And I'll come on to that in a moment. The question that we come down to on this appeal is how does that mesh with the imposition of a common law duty of care, which also has to mesh with the statutory obligations, because ultimately the common law duty of care is only going to be imposed if it's fair, just and reasonable in all the circumstances, and this forms part of the matrix, which forms part of those circumstances.
I mean, we read that the airline operator at D has the obligation to control operation areas to prevent or deter unauthorized access to aircraft. Are you saying the airports have no obligation to control?
No, I'm not saying.
No. So what's the nexus?
The nexus is twofold in terms of the analysis of common law duty of care, because ultimately, as I've already said, that can only exist if it's fair, just and reasonable in all the circumstances.
Well, before we get to the common law duty of care, as a matter of practice, how does an aircraft owner operate a restriction of access to his or her aircraft when the airport authority is presumably in charge of the entire airport? How is it done?
Because, well, that's a difficult question to answer as a matter of practice, or indeed how it was done on the 26th of April 2007, which is all that matters for our purposes. There is a difference or a distinction between access to airside, full stop, which is clearly a responsibility of the airport authority, not found in the statute,
Yep.
but a responsibility in the non-statutory sense found in this framework of regulatory provisions. So there's access to airside, which is clearly falls on the side of my client. Access to aircraft doesn't necessarily do so. And the reason this becomes acute in our case is because of the judge's assumption, I'm going to call it, but it is called a finding by the Court of Appeal, that nobody was allowed, or rather this plaintiff, and therefore nobody else, was allowed to provide their own security.
Can you help me? This aircraft was parked on I think it's called a ramp. Was it an exclusive ramp for aircraft owned by the claimant, or was it a ramp where anybody's aircraft might be parked, rostered to be parked? I mean, you're presumably told as you taxi in where to park.
I don't know the answer to that question specific to the date in issue. I don't.
Yeah, but
understand.
I can quite understand 3.15D applying to an operation area under the control of one aircraft operator. My difficulty is understanding how it would operate and apply to an operation area that was shared between a group of airline operators, but under the overall airside control of the airport authority?
I have to be honest, and I don't know how it works on the ground, if I can put it like that. And I don't know whether the specific area, whether you define that area, was shared with other parked aeroplanes overnight. But it arises in our case in this sense, and we'll look at a provision in a moment that flushes this out, which is that it depends on the aircraft to some extent, because if you have an aircraft that can't be accessed by someone just leaning up and turning a handle and pulling down the stairs and getting in, then that obviously the responsibility for security on the part of the airline operator and access to that aircraft would take its meaning from that situation. But that's not our situation in this case. This aircraft, as is common ground, was capable of being accessed by literally leaning up and turning the handle. It didn't lock, and it had its built-in stairs that came down, so anybody could have got in and done that. So in a sense, it may not matter whether you're sharing an apron or a ramp with someone else's planes parked overnight. But what really does matter is, is your aircraft vulnerable, which you as operator know by definition, because you bought it or leased it, and it's your employees who operate it and your mechanics who service it, but which the airport authority doesn't necessarily know, because there's no evidence or allegation or finding that that piece of information was crossed the line and was told to anyone in the security department. And then what onus does that put?
Sorry, I didn't understand. There's no pleaded allegation based on 315B, is there?
No, there's no reference in the pleadings at all.
So no one at trial examined what actually that involved in practical terms?
It wasn't gone into, my lord. The closest we get is Milo Butler III's witness statement, and then his testimony at trial on, I believe, day 4 of trial, but it's mostly in his witness statement. But in fairness, and this happens on both sides in this case, I've noticed, and it happens in negligence cases as well, you have witnesses speaking with some authority, because it's their job, about things like responsibility and accepting responsibility or denying responsibility. Ultimately, that is for the court to decide whether a duty of care exists and whether an assumption of responsibility has taken place. And witnesses say things what they believe to be the case by reference to, in this case, regulatory frameworks.
What I don't quite understand is how referring us to 315B enables us to go behind the judge's finding that operators weren't allowed to provide security if it wasn't examined at trial.
Well, it forms part of the evidential rubric that necessarily arises when we look at that finding. And in my submission, of course...
I don't understand that. What do you mean by the evidential rubric?
Well, in my submission, to call that a finding is generous, because it was a throwaway, in my submission, it was a throwaway assumption, which is not then analysed by the Court of Appeal. And we are here today to, in a sense, look at what the Court of Appeal did wrong.
Was it challenged in the Court of Appeal?
It absolutely was, and I was going to show you that in due course. But there was no, in my submission, just so you know, and you have it, there was no evidence, no credible evidence to support that finding, which I will call a finding without prejudice to my case about it, which is that it was no more than an assumption. It's unanalysed at first instance, it's totally unanalysed on appeal, and it is potentially important. It's not the be-all and end-all, but it's potentially important. And a lot of the discussion we've had around these regulatory documents feeds into that narrow point, the judge's assumption that an airline operator was not allowed to provide his own security. He could, as a matter
Anyway, you'll show us how it was raised before the Court of Appeal, will you?
I will do that. Can I show you briefly section 14 of the same document before we leave it? And that is at bundle page or record page 705. And it's headed Part 14, Security of Aircraft, and 14.2 says Protection on the Ground. And it has 4 paragraphs which are not numbered. The first one says aircraft remaining on the airport overnight will either have its stairs removed or doors locked, or both. And we know, of course, that this airplane had neither. Patrols by the airport security and the police force ensure the security of the aircraft during those hours. So that is relevant, I accept, to what I've called the rubric. Second paragraph, it is the responsibility of aircraft operators to ensure that their aircraft are not left unattended and unsecured. And in my submission, as a matter of common sense, that really ought to be read with the first sentence of that first paragraph, that if you know as airline operator that your model of aircraft does not lock and can be opened by anyone by reaching up and turning a handle, then your responsibility to ensure that it is not left unattended and unsecured is all the more engaged. And when you have not told the airport authority's security department and have not asked of that situation and have not asked them to look out for your, to send a patrol around, especially to look after your aircraft because it is so vulnerable to theft or tampering, and when you have not requested that you can keep a person parked on the ground overnight, as it were, your own person, watching over that vulnerable aircraft, then that all has to feed in to what is fair and just and reasonable. And whether that comes in under the limb of proximity or at the final limb is obviously a matter of conceptual debate. The judge put all of that in through proximity with his assumption that an airline operator was not allowed to have any form of person on the ground to look after his vulnerable aircraft. And that's where we say the judge fell into error in a factual sense.
But there was other evidence from Mr. Rowe.
It was. We'll look at that in due course.
To the effect that
that is opinion evidence in my submission. But
true, but there was other evidence that we should need to look at.
So we can put away 3.2. I was going to show you back in record 1 the agreed statement of facts, because it's an important document in an appeal like this, certainly where there is a difference of characterisation between appellant and respondent as to what the appeal is really about. Because agreed statement of facts is a comprehensive document. It's a document negotiated between leading counsel, not me at the time, because Mr. Griffiths is obviously now Mr. Justice Griffiths, which is why I'm here doing this one. I don't know if you had an opportunity to read through this document in background. Can I just bring some matters to your attention within it? It does bear rereading, and in a sense I would rest my factual case pretty much on what is in here, and I was going to take you to a couple of the references in due course. If we can pick it up with the heading, How the Aircraft Could Be Stolen, on 68.3. And paragraph 13, I would invite the committee just to refresh their memories as to, some of which we have traversed a moment ago. Then get in paragraphs 14 to 22 references to the evidence which was received by the trial judge. And I was going to pick it up again in paragraph 23, because paragraph 23, in a sense, is the paragraph that matters for the so-called private security findings, I've called it. Because if the committee were to read paragraph 23, you see a reference there to 3 items of evidence, or 3 pieces of evidence. You have the witness statement of Mr. Roll on behalf of Western Air. You have then the cross-examination, it should say Ferguson XX, with the reference to 96/981. That's actually Mr. Ferguson. He was the director.
Sorry, I'm not with you. I was trying to read the paragraph.
Sorry, my lord, I did jump ahead slightly. I was on paragraph 23.
Yes.
And what that does is it contains references to 3 separate pieces of evidence. The first 6 lines or so is to Mr. Roll's witness statement. The next 4 lines or so are actually to Mr. Ferguson's cross-examination, not Mr. Butler's. So I'd just invite the committee to make that correction. Okay. And then the final 3 or 4 lines are to Mr. Butler's cross-examination. Now, what I was proposing to do is to look at that evidence when I go through the judgment in a moment, rather than right now, if that's okay, and then just finish our review of this document. Over the page in 25 and 26, you see the references to the AASP and the NCASP and the Chicago Convention. I've just shown you the underlying documentation. What this document then does is it continues through what happened on the ground on the night, 27 through to 30, summarises the relevant evidence as to what occurred, and there's no evidence of any of the security officers having let anybody through who shouldn't have been. Right, there is then in 31 to 34 some summary of the evidence as to the use of identification cards. Obviously, the system allowed people who were authorised to go airside on presentation of their identification card.
It wouldn't follow that if an employee turned up with a card at 5 to 12 at night, that you would let him through.
It's difficult to answer that question, my lady, because it's not something that was interrogated at trial.
But the mere presence of somebody, mere fact somebody is an authorised person doesn't mean to say you'd let them through. You'd have to take account of the circumstances.
I'm going to answer that on conjecture, on the basis of conjecture, which is you would have thought so. But of course, nobody knows. If indeed the thief was Mr. Terreros, and I would say that the evidence points towards that being highly likely, and he remained a suspect at the time of trial, some years after the incident itself, we don't know if it was him and he waved his card and got through. We don't know when.
No.
We could have done it earlier in the evening. But there we are.
Then quietly laying doggo on the plane for several hours.
Got into
it
the plane.
Got dark.
Yes, he might have had a nap before the flight. We don't know, I'm afraid. There is 35 onwards is basically 35 contains the phrase landing is the difficult part, which is my favourite phrase in this case. But what it is dealing with on a more serious level is that it's explaining how the aeroplane could be accessed and operated. Over the page, you have details 36 through to 38 about the personnel who'd had access to the plane on that day, including the mechanic, etc. And 39 to 41 is what then deals with Mr. Terreros, and I've made reference to that in the appellant's case. I wasn't proposing to go over that now.
41, the evidence of Sergeant Lewis for Western Air. I rather thought he was called by the airport authority, although he may have given evidence that was rather favourable to Western Air.
I think that's a typo, and I thank my lord for pointing it out. He wasn't a witness called by the airport authority.
Yes.
And I take your observation on board as to what he said about other matters, one of which, of course, was the control tower, which I don't think seems to feature in the critical reasoning below in the Court of Appeal or indeed before you today. And then finally, if you just finish up 42 through to 45, that's where you get the reference to the control tower and it not being within the responsibility of the airport authority. You get a reference there to...
Can you just explain 42 to us? Your case at trial was that persons unknown stole the aircraft, that Western Air provided security officers at the perimeter fencing of the airport.
Well, that looks...
What did that mean?
I hadn't picked up on that. I don't know what that means. I'm wondering whether that's potentially another mistaken reference to the airport authority.
It must be.
Well, this is agreed by two leading counsel. Anyway, let's proceed.
It was, and it's, yes. We'll check on that, my lord.
Okay.
That seems right to me. I hadn't picked up on that, and I apologise.
Okay.
I think that suffices for that document. There is a reference, if you jump forward to 68.15, to a recitation, as it were, of the issues that arise before this committee. Because you will have seen that there is a plethora of appeal grounds, both when it went from first instance to Court of Appeal. I think there were 12. And I think by amendment there are also 12 against the Court of Appeal, appealing against the Court of Appeal before this committee today. And an attempt was obviously made by leading counsel in these paragraphs to put that into question form to assist the court, one of which I should say at 69.2 on 68.17 expressly brings in the point about the trial judges, or at least the Court of Appeal's acceptance of the trial judges' so-called private security finding, just so you know that it's there. The next thing to look at, I think, is the judgment itself. That is in Record 1, Tab 6, starting at page 69. And I produced a summary of this in the appellant's case, which involved observations as it went along, so some of that I'll unfortunately repeat. The Paragraphs 1 to 5 is where you find the dismissal of the breach of statutory duty case. I don't think we need to say any more about that. It really wasn't pressed at trial. Paragraphs 6 and 7 are very important. They come under the heading of the law. And what the learned judge did in 6 was cite his own decision, and we make no criticism of him for doing so, in the Albert Roll case, which he had decided or handed down a week before this trial came back on. This trial was split and went part heard 2 days in May of 2012, 2 days in September, and just before it resumed, the same judge, Mr. Justice Adderley, had given judgment in Albert Roll, and therefore he cites his judgments at paragraphs 41 to 44 from that case. Just so you have the point in mind, and it is in the written case, the Albert Roll decision concerned a claim in the employment context, where basically an employee sued his employers for having suffered personal injuries whilst at work. So it's one of those cases which engages personal injury. It engages a relationship, a contractual relationship, which supplies all the proximity you would need. It's a claim properly analysed, probably, of a concurrent duty under both contract and tort, because there would be the safe system of work allegation or concept would be engaged there. And it is materially different, but it didn't stop the learned judge from going there for the general principles. And so he cites 41 to 44 of his decision. 41 refers to Mitchell and Glasgow, and we'll look at that in due course. And then 42 cites Everett and Komojo. Now, Everett and Komojo is another personal injuries case. This is an English Court of Appeal case, and this is the case where the nightclub customer in the Metropolitan Bar, or the Met Bar I think it was known, was subjected to a physical attack from a fellow customer, and that was a case where that plaintiff sued the nightclub operators, Komojo, for alleging that they owed him or her a duty of care in that situation as well. Again, another personal injuries case. And what I'm building, and you'll have seen from the way we structure this in the written case, is that one has to be careful by resorting to, and this is what we say was the mistake at first instance and in the Court of Appeal, of resorting to cases which are from a materially different legal sector, if I can put it like that. Personal injuries cases taking place either in the private confines of, in one case, a nightclub, in other cases, even more strongly, employment contexts, and taking from those, just because those cases talk about the three-limb test, the three-stage test from Caparo, you can't just then say, well, three-stage test just applies to our situation, because our situation is materially different from those. It's materially different from Caparo and Dickman, which enunciated the three-stage test, because it is a statutory entity that is sought to be held liable at common law for the criminal conduct of a third party. It engages different strands of jurisprudence, as you know I say. The crucial paragraph, in a sense, in this whole judgment is paragraph 7, which we get to at the bottom of page 71. So based on the citation of Mitchell and Komojo in Roll, the judge says, applying the three-stage test to the facts of this case, and then you get unnumbered or unsubnumbered 1, 2, 3. First of all, close proximity, by virtue of the fact that only the defendant could provide the security in issue because the plaintiff was not allowed to provide its own private security. You know I take issue with that. We say that was an assumption. It's unanalysed, it's unreasoned, and it was swallowed whole, if I can put it like that, by the Court of Appeal, despite being a specific ground of appeal.
But even if you were right about that, and the evidence did show that the plaintiff was allowed to provide its own private security, would that really detract from such obligations as would otherwise exist in your client?
Well, we say those obligations aren't there for reasons.
I know you do.
Yes. But we have focused on that assumption, let's call it a finding, because it seems to be stitched in as such a critical part of the judge's arrival at the conclusion that it was the right thing to do here to impose the duty of care. And as I alluded to a moment ago, it was specifically challenged in the Court of Appeal, but just waved through. I used the phrase swallowed whole, and maybe that was discourteous, but it wasn't analysed at all. No. And that is regrettable as a matter of process and procedure, but it's insofar as it is important. And I have to say, pausing there and being an advocate for a moment, or being adversarial for a moment, there are umpteen references to the private security finding, not using my label for it, but using the gist of it in my learned friend's written case. Many references, even when she's analysing the law, and even when she's analysing the law relating to public authorities owing statutory duties, you see time and time again resort back to this critical finding. So she says, I need to overturn it. I don't think I do, because I think the legal approach to duty of care in this case below and in the Court of Appeal was fundamentally misconceived, because it ignored the statutory context and it ignored the law about liability for omissions. It just didn't go anywhere near any of what it should have done. I don't need to overturn this, but you should. But it seems to me that my learned friend is desperate to cling on to this finding, so that may answer the question, even if I did so in a forensic way. That was limb 1 of 3.
So when the plaintiff lands a plane at your airport and pays at the end of the month for that, what is the plaintiff paying for? And why isn't there an implied obligation to take reasonable care within, as it were, sensible confines, by which I don't mean the aircraft on the apron, but the airport side of it? Why wouldn't there be an implied duty of care as part of what is being purchased?
Well, we don't know what the fees are, so we don't know what they're paying. The statutory authority is empowered by statute to charge those fees, but it's for use of its facilities. And the primary, again, this goes back to that point of avoiding the temptation to look at all of those broader duties through the narrow lens of what happened in this case. They are paying for the right to use the airport for flights, to charge their customers money, and in some cases to park their planes overnight if they can't get the plane out or they're not scheduled to do so. They're not paying those fees just to park their plane overnight and with the expectation that that carries with it some form of protection. That's not what's going on. It's just that you pay the fees and you pass them on through your ticketing pricing, and we all know that that goes up periodically. So we just have to avoid that temptation to see the fees and to see the concept of security as only about what happened here, because we're inheriting what the incident here.
But in a sense, we know from the regulatory documents you've shown us that part of whatever fee they had to pay was going to go to the provision of a perimeter airside security structure, because that's something which the airport authority had to provide and had to get the money somewhere to do it, unless it's simply doing it out of taxpayers' funds. So it's a fair assumption, isn't it, that whatever the landing fee arrangements were going to take into account the cost of providing a secured airport, unless it was just a strip on the beach, as some airports are, where there's open access to everybody, including SEALs.
Yes. Well, again, we have no evidence, and there's nothing before you to show what the streams of revenue are. Airports make their money in lots of different ways. Landing fees and parking fees, but also all the rent on the shops and everything going on.
But as you're coming down, what you're getting is an airport with a 6-foot, was it a 6-foot or a 10-foot or
8
security fence around it?
Well, amongst other things, but primarily you're paying for the right to use that facility to make money yourself. It's a commercial operation. And like I say, there's different streams of revenue that flood into the airport authority in order for it to do its job and perform its functions aren't in evidence. And so I think it would be dangerous to assume parking fees or landing fees go to maintenance of the fence and the payment of the payroll for the security officers. It goes to many things.
I mean, there's obviously a duty of some sort. I mean, if someone cut a hole through the fence and the authority failed to mend it, and people got in and caused damage, I mean, that surely would attract liability, wouldn't it?
Well, but it begs the question, for what, though?
Well, for whatever damage was caused. I mean, would you not accept that in that sense it's clearly a duty on the authority to take reasonable steps to mend its fence, and not to expect the airport operator to mend the fence, not to expect the airline operator to mend the fence?
No, I don't. Well, I don't think on those bare facts that I would. No, I think you have to approach this always through the statutory framework, and then insofar as it is sought to impose a common law duty of care across that framework, you then have to start with the relationship, as it were, between the parties. You have to look to see whether there is the proximity. You have to look to see whether it was reasonably foreseeable. That's the one that's usually just ticked. But we all know in these sorts of cases where someone is being sought to be held liable for the criminal acts of a third party, that the reasonable foreseeability of that harm is not enough. It simply is not enough. So you often tick reasonable foreseeability. And then you have to take a step back and ask whether it's fair, just, and reasonable in all the circumstances to impose liability for that loss. But there we are. So that is, in a sense, the critical part of the judgment. What the learned judge then did, and I'm conscious of time, is he recited what he regarded to be the scope of the duty in 8. He says, in my judgment, the scope of the defendant's duty extended to not causing or contributing to the very act that occurred, the theft of the airplane by persons unknown or unauthorised. What needs to be considered is whether the defendant was guilty of any acts or omissions that caused or contributed to the theft. He recites certain particulars from paragraph 10 of the re-amended statement of claim, and then he goes on in his paragraphs 10 through to 20 to recite aspects of the evidence that he had heard. He does that under 2 headings, security system and security staff. And then he says in 21, it's not known how the unknown person gained access. And in 22, he delivers his res ipsa loquitur finding, about which we do make a criticism if we get that far in the analysis. And then interestingly, in 23, he comes back to deal with a submission that was made to him about special relationships, and we will move on to the law shortly. But what this shows is obviously is that the point was pressed at first instance, the legal point, which echoes the legal points I am making today, that even outside the statutory context, when you are seeking to hold a defendant liable at common law for the criminal conduct of a third party, you are looking at a line of case law that requires a special situation. And we'll look at the case law as summarised in Clark and Lindsell and in relevant authorities in one moment. That point was made to the learned judge, and he dismissed it. He dismissed it in 23 by reference to a case called Wallace and Moscows. That is a Bahamas Court of Appeal case in which, and I've mentioned this in the appellant's case, the submission that you need a special relationship was dismissed or not accepted, but in circumstances where the tortfeasor had created the danger, which is one of the classic examples, as we'll look at in a moment, for where you can be found liable in negligence for the criminal conduct of a third party, because you have created the danger. In the Wallace case, I think it was builders in the adjoining, one of these cases to do with adjoining landowners, and the defendant's building, he had builders in, and they had removed all the ceiling tiles and then left the premises in a certain state, and naughty people had come in, they'd gone up into the ceiling void, crawled along, gone down into the plaintiff's property. Did there need to be a special relationship? Court of Appeal of Bahamas said no, there doesn't. But obviously in a case like that, you have creation of the danger. The tortfeasor, as landowner, has created the danger. And so the judge would try to head off that whole line of cases, and he did that there. You then get the heading damages, and I don't think an awful lot really turns on that. You have the point that the main claim was dismissed. The claims which were allowed, however, are in the nature of economic loss. It's interest on a bank loan of $83,000, and its increase in the insurance premiums, which came in at $750,000. So it is economic loss, and that distinguishes this case from all the cases which are otherwise sought to be.
But is it pure economic loss? I'm asking that question because the absent party at this particular function is the insurer coming back through the operator by way of subrogation, in which he'd be saying, this isn't economic loss, my airplane is now a write-off, I can't get it back. But various economic consequences flow as it were, secondary forms of loss. Is this pure economic loss?
I don't think it is. No,
No,
I've seen
good.
a reference to that in the appeal grounds, and with respect to the person who settled them, I don't think this is a case of pure economic
Thank
loss,
you.
because this is economic loss, and indeed that is how it was described in the closing submissions of the plaintiff itself. But it isn't pure because it flows from theft of a chattel.
Quite.
But what it certainly is not this case is bodily injury and personal safety, and so much of the case law referred to at first instance and in the Court of Appeal that we'll look at in a moment comes from that area of the law where there are heightened policy considerations, because the plaintiff is found to owe a duty of care, the defendant is found to owe a duty of care to the plaintiff to protect him or her from injury on his premises or in his employment. They are fundamentally different juridical and factual contexts to those cases, and it was an error of law on the part of both the judge, so far as relevant today, and certainly on the part of the Court of Appeal, just to take those cases and extrapolate from those cases that a duty of care was appropriate in this particular case. An error of law on multiple levels, statute, omission, type of harm. You have the submission. Can I show you, briefly, because I said I would, the evidence relevant to the private security finding, as I am calling it? And for that, we can look in three places. First of all, Volume 2, to the witness statement of Mr. Roll. I'm going to show you three pieces of evidence briefly, as summarised in paragraph 23 of the agreed statement of facts, and this is the first of the three. That witness statement appears in tab 21, bundle page 276. And Mr. Roll, as we know, as he says in paragraph 1, is the president, and at the time was the president and managing director of Western Air. So he was speaking for his company, and in a sense he was making the claim for his company. I was going to ask the committee to pick that up at paragraph 7 on page 278. And it might be easiest if you just read that through to paragraph 12.
Yes.
And also, before I make observations about that, it might be an idea to note what he said about paragraph 13, because that goes back to the company's adoption or not, as the case may be, of its own security programme. He says in the middle of 13, the plaintiff simply adopted the programme proposed by the CAD, and in particular, Article 14.2. That's what I showed you earlier. And then he recites those bits I showed you, that the aeroplane should have its stairs removed or doors locked or both, and that the patrols during nighttime hours from the police and then also it was also the responsibility of the aircraft operators to ensure that their aircraft are not left unattended. So he's rehearsed something I showed you earlier. What we're looking at for present purposes is really 12, but 12 builds on what this gentleman said in 7 and beyond. In 7, he talks about parking fees being billed periodically, and he says this at the end: implicit in the payment of the parking fee is the provision of tarmac space, security, and the ability to enter and leave, ingress and regress. In 10, he says, since going into operations at the airport prior to 2000, the plaintiff entered into an oral arrangement with the defendant for the lease of office desk space, landing fees, parking fees, passenger screening. He talks about monthly invoicing. In 11, he says, during the course of the said arrangement, the defendant always provided 24-hour security services on the tarmac. And then in 12, he says, in that context, it is understood. He puts that into the passive sense. It is understood by virtue of the arrangement, which I'm assuming he means the oral arrangement, through conduct over the prior years, and through various discussions with the managers. He doesn't say when, he doesn't say who, he just says the managers, that individual tenants, lessees, so he's not just talking about himself, he's talking about all users, cannot provide their own security at the said airport. It is and has always been that, and then I think you ignore that only the airport authority, the police or the contractees are responsible for the security. That's a comment about what he understands people's responsibility to be. And my Lady Arden, asked me about this, or alluded to it a while ago, and I said, well, it's opinion evidence, and it is. It's either vague, a vague
I mean, you can criticise the evidence, but it doesn't matter before us if it wasn't challenged at trial, does it?
Well, I'm going to show you what the evidence was against this and why the judge fell into error in making that assumption or that finding. I think it's said...
Do you go as far as saying this is inadmissible or just weak?
I don't say it's inadmissible, I say it's weak when it's compared to the evidence of what was actually the case. And indeed it wasn't relied upon, interestingly, by the plaintiff in its closing submissions. Can I show you the other two pieces of evidence briefly? And then can we get to the appeal?
I'm right, paragraph 13 is read by the buyer, isn't it?
I think so, yes.
This is subsequent.
It's on a different point, but I thought I'd show you because it picks up on something I showed.
But it's also subsequent to the 2007 theft.
I don't know if that is clear, but I don't think anything turns on it, and I don't press it. If we can put away record 2 and go to record 4, which are the trial transcripts, and we'll have a very brief dip into these only. The trial took place over 4 days, so if we go to day 4, which is tab 96, and if we can pick it up, please, at 981, which is transcript page 34. These transcripts do come with their own disclaimer at the bottom of each page, which says rough draft, and there is something in that, because I think all the references to apron 5, which is where this aircraft were parked, come up as sometime, well, not all of them, but some come up as EY5, for example, so one has to approach them with a bit of caution, but I don't think anything matters for our purposes. This is the cross-examination of Mr. Ferguson. He was the incumbent head of security director. He wasn't in post at the time of the theft, but he was in post by the time of the trial, which was 5 years after the theft. And I would invite the tribune, so the committee, to look at lines 4 down to 22.
I'm so sorry, what was this man's name?
Mr. Ferguson, Osborne Ferguson, my lord.
Ferguson?
Ferguson, yes.
Yes.
And the key part of that exchange is lines 16 to 22. As the question was asked, and this is cross-examination, would you, as Director of Security, and I'm paraphrasing, allow Western Air to have another security team come and act as security for their aeroplanes? And he said, yeah, if they make an application for it, it would be reviewed, and if they so wish to do, we will try to facilitate. I think if you read on, there may be a part on top of the next page which the plaintiff relied on in closing to support the private security finding. So if you were just to read on and read EY5 as apron 5 each time you see it, and just read maybe to the middle of the next page, to page 982, just so you've seen it. And then I'll show you Mr. Butler's evidence.
Where do we stop?
I would suggest round about line 14. Or
on 982?
Correct, my lord.
Yeah, thank you.
But I'm just showing you that out of fairness because it may save time later.
Right.
The points that matter are that you have the incumbent Director of Security saying if they'd asked, or if someone in their position asked, we would have looked at their request and aimed to accommodate them. That is flatly
Try
opposite.
to facilitate, the exact words.
Yes.
It certainly doesn't partake of an assertion that they would be permitted to provide security.
No, but it's, when I say no, what I mean is it's an important piece of evidence if a judge is going to then say, in terms, you are not allowed. And it was a piece of evidence that was not looked at all and runs counter to that finding. And there is another piece of evidence which does so in a more concrete way, and that's Mr. Butler's cross-examination. And that's on the same day of trial. If you go in the same transcript of 1007, Milo Butler III was the incumbent general manager of the airport authority at the time of trial, but not at the time of theft. Because, as I said, 5 years had passed between the theft and the trial. And can I ask you, please, to take note of line 9 on page 1007 down to line 3 at the top of page 1008.
Yes.
And obviously it's the answer at lines 1 to 3 at the top of page 1008 that I would rely on. Here you have someone speaking from his own experience when he worked for a different airline, Spirit, I think it was called, dealing with this airport authority, and as I understand it, therefore, this airport, saying we asked for our own private security and we were allowed it. He says it was subcontracted out, it wasn't airport security personnel. No consideration of that evidence in conjunction with the other when the judge made the inference or the assumption that he did when he said not allowed. If we put away record 4 and go, please, back into record 1, and this is, I was going to show you briefly the plaintiff's closing submissions at trial on what they said about this. And that is tab 14, and it starts at 123. It's the yellow page, so I can see that my lord has that one. So this is the written closing from trial. So this predates, obviously, the judgment we've just been looking at. I was going to show you 2 references. On page 135, which is internal page 12, this is paragraph 5.2e, where the plaintiff was dealing with what the defendant's witnesses had said. You see the heading Osborne-Ferguson. And if you look in the penultimate paragraph on that page, it says, Mr. Ferguson freely admits, and that's the transcript, page 35, that I just asked you to read on to. And then it says this, he confirmed that aircraft owners were not allowed private security on the airport and that they are subject to the security program and security personnel of the defendant. So the case being advanced by Western Air at the end of trial on this point was only by reference to Mr. Ferguson's cross-examination, not by reference to Mr. Roll's witness statement, tellingly. And indeed...
But counsel for the plaintiff is not obliged to rehearse all of the evidence called on behalf of the defendant.
Sorry, my lord.
Counsel for the plaintiff is not obliged in her closing submissions to rehearse all the evidence called on behalf of the defendant.
No.
But you say he gets this the wrong way round.
I'm saying 2 things. I'm saying, first of all, it's telling that in order to press this finding on the trial judge, which succeeded, he didn't go, or she, I should say, because it was a female advocate who did the trial, she didn't go to Mr. Roll's witness statement to make any reference to it, which is now relied on, as I understand it, to support that finding. So that's point 1, what is not there. Point 2, what is there is wrong. Because Mr. Ferguson did not say that private security was not allowed. The only reading of what he did say suggests the contrary, and I take the committee's observations about that evidence and its weight from a moment ago. But what he certainly did not say was what is said there that he said. And they come back to that point on page 138. This is internal page 15, and it's paragraph 7.2 of the closing. And in the middle of the final paragraph before 7.2.1, so effectively the middle paragraph in the page, or just below the centre point, 4 lines in, the conditions of use of the airport are implicit in the arrangement. Well, that might at most be a reference, an allusion to Mr. Roll's paragraph 7 and 10 that we looked at, but it's not cited. The plaintiff was entirely reliant on the defendant for the security of its aircraft at the airport and was not allowed.
Sorry, where are you?
I'm on page 138 of the record,
Yeah.
and there's a paragraph that starts in the present case.
Oh, got it. Yeah, thank you.
Yes.
Yeah.
And it's the 4 lines of that starting at line 4, the conditions of use. Now, to call the reference to conditions of use is a novelty because, of course, Mr. Roll in his witness statement had only talked about an oral arrangement and parking fees and what he believed to be implicit and what he understood to be the arrangements. So the reference to conditions of use is something of an exaggeration. But again, here there's no citation of any evidence. I'm just showing you what the plaintiff said to urge this finding on this judge, a finding which the respondent now says is important, or seems to be assuming.
Just as if, had the submissions been oral, yours would have preceded theirs, so that your written submissions, which start at 151, preceded these. Is that right?
I'm not sure about that. They have different... Ours are dated 23rd of October.
Quite. This is
Yes.
26th.
It looks like they were sequential, yes. Yes. But I didn't detect anything in ours on this, because again, I'm conjecturing here, but and I'll be corrected.
I don't detect anything in yours which is in reply to theirs,
No.
which isn't very surprising, because theirs come in later.
Yes. And I don't think we preempted this point because it was never pleaded. I mean, this is, and I'm sorry to use that phrase, but there was never a case run, and there are no findings anywhere in this, below or in the Court of Appeal, to the effect that there was any specific assumption of responsibility, and we are going to come on to the law imminently.
And you've got to deal with res ipsa loquitur, so you've got a job on, Mr. Hounsman.
I do, and I'm conscious of that. But there was no case ever run that I've detected anywhere in the record of specific assumption of responsibility, and that is very surprising. There is no finding in the first instance judgment, there is nothing said in the Court of Appeal judgment that there was any specific assumption of responsibility. And in the legal framework that we are looking at here, of a statutory public authority being found liable at common law for the criminal acts of a third party, that is, if I may say so, astonishing, because the case, if it was going to be run, would have to be run on the basis of a specific and voluntary assumption of responsibility, because there's no suggestion that my client created the danger. There's no suggestion that my client controlled the underlying criminal or tortfeasor, the primary tortfeasor. And therefore, all you are left with on established English law principles in this area is specific voluntary assumption of responsibility. It is nowhere on the record of this case. It seems to be...
can we get on with the facts? Because, you're saying there's something wrong in the submissions at first instance. But if that's right, then the time to raise that was in the Court of Appeal.
Yes.
And you want to show us how that was done.
I'm about to do that now.
We'll come on to the law, no doubt, after that. But
Can I show you the appeal grounds very quickly? That is Record 1, Tab 12, starts at 115. And this is all summarised in the appellant's case, so I'm going to, with apologies, up the tempo now to finish in time. There were 12 grounds of appeal that we see on page 116 and 117. And as I've extracted in the written case, grounds 3 and 7 concern what I would call the threshold legal issue that's before this committee now, albeit at the next tier of appeal, which is the legal question of the imposition of duty of care. That's 3 and 7. 5, ground 5, is the specific challenge to the judge's finding, private security finding. That's the finding that I'm generously calling it in paragraph 7 of the first instance judgment. So that was there. And 4, for example, is the challenge to res ipsa loquitur. That's all I was going to show you there. If you go, please, to tab 17, which is page 197. This is the submissions of the appellant on the appeal.
197.
197, my lord, yes. And if we look at paragraph 10, and I'm going to just show you the references now to the challenge to the private security finding. Paragraph 10 on page 199, that's where it's identified as a target of challenge on appeal. If you then go forward, please, to paragraph 30 on 204. And it's paragraphs 30 to 33. In 31 in particular, there's a reference there to the evidence of Mr. Roll, Mr. Ferguson, and also Mr. Butler. I've shown you all 3 of those pieces of evidence. If you go forward to paragraph 51 on 210, and it's 51 through to 57 that matters. And what you see there set out for the benefit of the Court of Appeal in paragraphs 52 and 53 are those extracts from the cross-examination of both Mr. Ferguson and Mr. Butler that I showed you from day 4 of trial. So they are there set out for the Court of Appeal to consider. And then the submissions are made that follow on from that in paragraphs 54 through to 57. And then finally, if you go please to page 233, you see a heading number 3. The respondent was not allowed to provide its own security. And this then comes back to the challenge to that finding, and it's paragraphs 148 to 155. You do see then set out again the same extracts from the evidence of Mr. Ferguson and Mr. Butler more than once. So it was an express ground of appeal, and indeed loomed large in the written case on the appeal. Can we, with that in mind, please go to the Court of Appeal judgment? And that is at tab 8 and starts at page 83. And the judgment itself starts at page 85. And there is a reference in paragraph 7 to there having been 15 grounds of appeal, which I think was a mistaken reference to 12. Nothing turns on that. You see then in paragraph 8, they cite paragraphs 11 to 19 of the first instance judgment. And then in paragraph 9 on page 87, they recite the 3 broad bases of challenge, which was a challenge to res ipsa loquitur, Roman 1, Roman 2, an invocation of cases, Bahamian cases of malus and pickstock, and then thirdly, the appellant's owed a duty of care. So oddly, one might say, when coming to summarise what the basis of challenge was, the Court of Appeal put res ipsa loquitur first, even though that goes to breach or presumed breach of any duty of care, and they put the existence of the duty of care, the big legal issue for today's purposes, at point 3. And that, in a sense, resonates throughout this judgment, because I'll be courteous about this judgment, but I don't feel the need to be unduly kind about it, because in my submission, it's a muddle. It is a muddle. It deals with the existence of a duty of care in the same breath as the scope of it and the breach of it and causation, and in some cases in a different order to that. It refers nowhere at any point to any of the grounds of appeal, The best one gets for that is what I just showed you in paragraph 9, those three Roman points, which purport to summarise the 12 grounds of appeal. Crucially, at least crucially in the context of the private security finding, and we can see this by jumping ahead to paragraph 26 and paragraph 27, there is no analysis. I showed you appeal ground 5. I showed you the basis of that appeal against the private security finding, and all that happens, unfortunately, in paragraph 26 is that they say, in the instant case, the judge quite rightly applied the threefold test, and at paragraph 7 of his judgment made the following findings. And what they've done then is they've extracted from paragraph 7 of the underlying judgment and given them Roman numerals, the three elements of the three-pronged test from Capara and Dickman. And then in 27, they just say that was right, and in 29, they say ample evidence to show that but for the failure of the appellant's security, the theft would not have occurred. And that is it, unfortunately. And I do make criticism of that, both as a matter of the lack of analytical rigour that went into upholding the judge's finding below, and indeed its own independent legal error as well. Because if we go back in the Court of Appeal judgment to the heading above paragraph 15, so this is bundle page 90, you see there, when they come to set up the law on the imposition of a duty of care, you see a reference to Donoghue and Stevenson. Donoghue and Stevenson, this is in paragraph 16, comes with an enormous health warning by Lord Hoffman, and no doubt others, when one is approaching the question of the imposition of a common law duty of care in the statutory context and for omission. When you're seeking to hold a defendant liable in private law for the criminal conduct of an independent third party who's not in his control, Donoghue and Stevenson is not the governing law. There we are. Paragraph 18 refers to the Capara and Dickman three-stage test, which in my submission also comes with an equivalent health warning when one is dealing with statutory public authorities sought to be held liable for the criminal conduct of independent operators. 19 is where the central point on the appeal is rehearsed. This brings us to the central point in this appeal, that is to say where damage is caused on the premises of a person by the criminal act of an independent third party, whether that defendant is ever liable. No reference there to the defendant being a public service authority whose relevant operational responsibility is defined by statute, still less any reference to the fact that that statute was sought to be engaged and said to have been broken, and that claim was dropped at trial, which I say tells rather heavily.
But the authority has no discretion to decide which aircraft it will protect and which it won't. I mean, if we're thinking back to Stoven and Wive, the Highway Authority had a choice as to where to put the sight lines to the road, and so on. It's not a similar case, is it?
Well, my lady, I would answer that question by heading off the premise, or heading it off upstream. I don't think it has any responsibility to protect aircraft at all. It has a responsibility to provide security at the airport. And I think once you posit the question in terms of protecting aircraft, you've already fallen into, in my submission, conceptual error.
Well, we've seen that general responsibility is expressed in terms which include protecting aircraft in the most general terms. Isn't the more precise question whether there's a responsibility to protect aircraft from theft rather than from somebody coming and sticking a knife into the tyre, for example?
Planting a device.
But then that raises the legal question: is how granular is one's analysis of what kind of damage does the protection duty extend to? Sorry, I put that very badly, but I hope...
No, but I understand the point. But this goes back to the debate we had in the sense earlier on when we were looking at the statute. and it's simply, I mean, I'm not going to say that no part of the rationale for that responsibility to provide security concerns the integrity of aircraft,
No.
because they're parked there.
Well, they're clearly identified in
It's a small part, and in a sense, you have to look then at the regulatory context as well, which allocates the responsibility for owner as well as airport operator, or indeed landowner, because that's what this situation is as well. But it's telling, if I can just proceed through the judgment quickly, it's telling that in 19, they then go on to say such an issue arose for determination in Everett and Komojo. Now, Everett and Komojo is the nightclub case that I told you about. So they instantly invoke there, as indeed the learned judge had done in his own prior judgment, the Roller case, a bodily injury case which took place within private premises between contracting parties, because the person who enters the nightclub obviously has paid to get in and has his bargain with the nightclub owner, and then argues, well, I believe you owe me a duty to protect me from being stabbed by someone else that you've let into your nightclub. It's telling, in my submission, that they go straight to answer that, what they regard as the central point, straight to a case about bodily injury in the private context, nothing to do with public service authorities, and different types of loss, broader forms of loss. Komojo is then covered in 19 and 20. There is then a reference to, in 21 through to 24, to two Bahamian cases, Malis and Pickstock, both of which concern, or Pickstock's not in the bundle, but Pickstock is then rehearsed in 22 to 24. Both of those cases also, I think I'm right in saying, concerned bodily injury. I think one was a stabbing and one was a shooting in the private context, of where one of them, the plaintiff was working as a store manager in the defendant's store and said that he was owed a duty of care under both contract and at common law, not to be protected from robbers who came into the store and shot him. So the judge, at first instance, and the Court of Appeal, repeating in my submission the fundamental legal error of analysis, are looking at this case entirely through the lens of private operators and cases involving bodily injury. And then just to pick it up, there's the heading, Doctrine of Res Ipsa Loquitur. And what I say about that is going to be brief anyway, and in a sense I can rest on what I've said in the appellant's case because I'm conscious of time. I'm also conscious that if one bakes in the premise that you're against me on duty of care, both as to its existence and its scope, you may not be with me on Res Ipsa Loquitur, but who knows. That's all we need to look at in the Court of Appeal judgment, I think. Can we look at some law quickly? And best place to see a mapping of the law in my submission is Clark and Lindsell, and that we find in the authorities, the first bundle of authorities, that's Record 6, tab 3. The structure of Clark and Lindsell is important to bear in mind, because what is dealt with in Chapter 8 is the position common law for emissions, or at least in the section of Chapter 8 that we've extracted.
I have a page.
Oh, sorry, it is 1093A.
Thank you.
So what you have is effectively two sets of extracts from Clark and Lindsell. You've got the Chapter 8 stuff, if I can put it like that, which is the general law, not to do with public service authorities, but just the general law. And you've got the sections running through to 1095.5A that concern omissions, liability for omission. Classically speaking, liability for the criminal acts of an independent third party. You then also have an extract on Res Ipsa Loquitur, which is also from Chapter 8, and that's at 1095.5b, so 1096.2. Then you get a set of extracts from Chapter 14. Chapter 14 concerns the liability, well, it's headed Public Service Liability, and it concerns liability at common law or under statute of public service authorities, statutory authorities. And the principles obviously overlay one another. And in our case, they're both in there because both of those features are present, we say, present front and centre in the proper analysis of this case. Can I take you very quickly through what we say from Chapter 8 matters? And that is, if you pick it up on the very first page, paragraph 8-47, bundle page 1093A. And this is obviously the general proposition, which one sees enunciated, amongst other places, by Lord Gough in Smith and Littlewoods, that liability for omissions, generally speaking, the common law sets itself against liability for omission, or at least pure omission. The dividing line between omission and commission is not always the easiest to police. But our case, we submit, is a case substantively of omission, in the sense that my client did not steal the plane, and nobody for whom my client is responsible, legally, contractually, or otherwise, stole the plane. And it's never been suggested to be so. So it wasn't my client what did it. My client is said to have done something or failed to do something which allowed it to happen. So we are in the realm of omission. If I can ask you to go...
Omission to protect the aircraft, or omission to do what?
Omission to do something which allowed someone else to steal the aircraft, my lady. A failure to stop a thief, if you want to put it in...
Omission to stop
Yes.
someone from stealing.
Yes. So, and the key point being, we and no one on our behalf stole the plane, and that's the point. So we are in the realms of omission. And I think that's, conceptually speaking, not common ground based on the...
there's so little time to discuss this, but, I mean, we've only got to look at the first 4 lines of pure omissions, of 847, to see pure omissions, and then a reference to the parable of the Good Samaritan, which does rather indicate that the pure omissions involve somebody who has absolutely no obligation towards the plaintiff at all, but is to be criticised in limited circumstances for not, as it were, intervening, which seems so different from this sort of case.
Well, the parable analogy is different from this case. It's the classic parable that's set up to illustrate it. But the law on omissions is engaged here. It is, because for the simple reason, like I say, and at the risk of repeating myself, that we didn't steal the plane, and we didn't create...
You're responsible for the airport.
Why?
It's completely different to the Good Samaritan, who's not responsible for anything.
But the source of my client's responsibility for security at the airport is statute, and it is
I
not
know, we
said...
understand that, but you've clearly got a responsibility, and the one looking at the consequences of that. So it's not a pure omission case. It's a case where one's trying to work out what the extent of your responsibility is. So I'm not sure any of this helps us.
Well, I would part company with my lord on that analysis, if I may say so, because the engagement of the responsibility is something which engages potentially a duty, but it's a statutory responsibility with a statutory duty, and it doesn't alter the underlying reality of the cause of this loss. The cause of this loss was theft by an independent operator, an independent third party, for which it is said my client is responsible by having failed to stop him. Having failed, this is what it is said nebulously, having failed to stop him going through a gate or going through a hole in the perimeter fence, whatever it may be. But it is a case of omission, substantively speaking and functionally speaking. Can I just take you through... I would appreciate 15 more minutes, if that's okay.
Well, it isn't okay. From our point of view, Mr. Houseman, and if you wanted to have an extra 15 minutes, that should have been signalled at the beginning of the hearing.
It doesn't impact the overall hearing time, and I'm quite happy to forfeit 15 minutes from my reply
Right.
at the end of the day.
Are you happy enough for that, Ms. Deal?
I'm not going to have difficulty, my lord, in putting my submissions into the correct amount of time, even if my learned friend speaks for another 15 minutes.
Very well then. Let's get on with it.
Thank you. I'm grateful to everybody. The paragraph 8-51 on page 1093.1 deals with the 3 broad categories in which liability for pure omissions, as it's put in inverted commas there, is found to exist at common law. They are, first, a special relationship, which entitles one party to rely on affirmative action being taken by the other. Secondly, where there is a specific assumption of responsibility by one party to act affirmatively for the benefit of the other. And thirdly, where one party must bear a specific responsibility for protecting the other. Those 3 categories are then dealt with in the following passages that you have extracted for you. Over the page in 1094, you see the first of the three, protective relationships. And I'm going to show you that at paragraph 8-52 to show you, because there's a reference there. It's footnoted as 241 to the Komojo case. That's the nightclub case that looms large in the analysis in the Court of Appeal, in our case. And then a few lines down from that, you see it says the basis of the duty. So this is 6 lines up from the bottom of paragraph 8-52. The basis of the duty in these situations was said by Beldam LJ in Barrett and Minister Defence to be, and then there's that quotation, reliance, express or implied in the relationship, and if you read through to the end, make provision for his safety. So it's quite clear that those cases, the protective relationship cases, are concerned with personal safety. And if there was a case that properly fell within that rule and applied to something other than personal safety, we would have heard about it. If you go over, please, to 1095.1, this is the second category that we saw introduced, and this is specific assumption of responsibility. And 4 lines down, and indeed in the second line, this is dealing with cases where the defendant has effectively undertaken. Something has occurred in the communication and conduct which has crossed the line between defendant and plaintiff or claimant, which amounts to an undertaking. It says, I will look after you here. And that is telling, because that's what specific assumption of responsibility is about, and that's what it takes. And we'll look at it again in a moment in the context of public service authority liability. And that's not present in this case. It may be what Mr. Roll was trying to drive at in his witness statement when he talked about the oral arrangement subsisting over many years, but it is not the way the case was pleaded, and there is no finding at first instance or in the Court of Appeal to the effect, and indeed it wasn't even suggested that there should be, but there is no finding anywhere in this case to the effect that my client undertook or specifically assumed a responsibility to this commercial entity to protect its aeroplane. That's important. If you go, please, to 1095.3, we get to the third of those 3 categories, a specific responsibility for protection from third parties. And this then invokes Smith and Littlewood's, that was the Scottish House of Lords decision, again another adjoining landowners case. So many of these cases in English and indeed Scots law arise in the adjoining landowners context, about protecting one landowner having a duty to protect his neighbour effectively from incursion and damage by third parties allowed onto his own land. And that was the case in Smith and Littlewood's with the vandals allowed onto the disused cinema. But what I'm showing for you now is that Lord Gough in Smith and Littlewood's, whose opinion over Lord Mackay is preferred by the editors of Clark and Linsell, as you can see from the bottom half of paragraph 8.55, Lord Gough identified 4 categories which would invoke a specific responsibility to act. And they are A, assumption of responsibility, it comes back in there. B, a special relationship based on control by the defendant. So that's where the third party is under the control of the defendant, which one can definitely analyse or readily analyse the Dorset yacht case as. That's the Borstal boys running havoc on the island. C, responsible for the danger. No one is suggesting that the airport authority is responsible for the danger. It didn't create this danger. And D, where the defendant is responsible for property, which may be used by a third party to cause damage. That's like where fire spreads between properties or thieves get access through neighbouring property. That's not our case here. I'm showing you this now to show you subcategory A, assumption of responsibility to the claimant, which starts at the bottom of that page, and then over the page on 1095.4, paragraph 8.57. Assumption of responsibility by public authorities. Such cases are extremely fact-sensitive, but as a general rule, it would be rare for a public authority to be found to have assumed responsibility to a claimant to protect them from harm caused by a third party. And in my submission, A fortiori, where that is economic harm based on theft of a chattel, is distinct from physical bodily harm. And then you see in the ensuing paragraphs, each of those, although they're not lettered in this way or labelled in this way, each of of those A, B, C and D from Lord Gough's speech described. I was going to then go, please, to the extract from chapter 14 of Clark and Lindsell and pick it up at on page 1103. So we're now in the section of Clark and Lindsell that deals specifically with public service liability. Obviously, it overlaps when you're looking at emissions liability with what we just looked at. The paragraphs that matter, I might just give you the references to assist with time. It's paragraphs 14-60 through to 14-66. It's 3 pages. And I rely in particular on what is said about the need for assumption of, well, if you look at 14-62, you see the reference to Mitchell and Glasgow City Council. That was another Scots House of Lords appeal. And the 3 subcategories there, again, resonating with what we've looked at in Chapter 8, the 3 subcategories of circumstances, special circumstances, in which liability is imposed on public service authorities for, let's just call it, the criminality of third parties that have caused damage to a plaintiff or a claimant. Number 1, creation of risk or danger. Number 2, control or supervision, with the reference to Dorset Yacht. Number 3, assumed a relevant responsibility. And I would ask you to pay particular attention to the assumption of responsibility heading which follows, because that's at 14.63 to 14.65 and makes very clear that an assumption of responsibility has to be both specific and voluntary. Specific in the sense that it has to amount to an undertaking or something in the dealings between the parties whereby the public service authority has effectively undertaken to look after that entity against the risk from someone else. And it has to be voluntary in the sense that it has to be something freely undertaken and not something it's required already to do by statute. Can I ask you please to go back to page 1100. And as referred to in the written case, we specifically invoke what is said by Lord Hoffman in Stoven and Wise and in the Gorringe case, both of the road traffic or road signage cases, if I can put it like that, which is referred to here at 1458 and 1459. I would like to briefly, in the remaining time, just go to those cases so you have the relevant extracts.
Do they tell us anything more than we get from this? I mean,
it will, in the sense that there are a few more references that I think it's important that you have in mind.
I don't think there's any dispute about this. Is the principles? The question is how you apply them here.
I think that, well, I would appreciate a minute or two just to show you it in situ, as it
Right.
were.
Proceed then.
Stovin and Wise is in the Authorities Bundle 2, which is Record 7, tab 13, 1-3, and the page is 1333. And I wasn't going to spend time, because I don't have it, on the facts of that case, but I think from one of the earlier questions, those facts are relatively well known. The section in Lord Hoffman's speech, this is a House of Lords case in 1995 or 96, is section 8, which starts on internal page 951 of the law report, which is bundle page 1361. And it's that section of the speech, and it runs through to the middle of internal page 953. And what is said specifically that matters is in F 952F to the top of 953. And it's saying that the policy of the Act, the scheme of the statute, as it were, is a crucial factor in determining whether a common law duty of care should be imposed. And then the quotation, which you see in my case, written case, and also in Clark and Lindsell, starts at H at the bottom of 952. If such a duty, he's talking about his statutory duty, if such a duty does not give rise to a private right to sue for breach, it would be unusual if it nevertheless gave rise to a duty of care at common law. etc. And then if we go to Goringe, which is authorities, the first authorities bundle, so record 6, tab 8, bundle page 1211. There are 3 references there that I wanted to show the committee. First of all, in Lord Hoffman's speech, paragraph 23, bundle page 1219. Where he says, if a statute actually imposes a duty, it is well settled that the question of whether it is intended to give rise to a private right of action depends upon the construction. If the statute does not create a private right of action, it would be, to say the least, unusual. I think he's added there, Lord Hoffman has added, to say the least, to what he had said about the same point in Stovin. It would be, to say the least, unusual if the mere existence of the statutory duty could generate a common law duty of care. If you go forward, please, to Lord Scott's judgment, paragraph 71, bundle 1231. Lord Scott is dealing there with Stovin and Wise. He refers 3 lines into paragraph 71 to what Lord Hoffman said at 952, which is what I showed you in Stovin and Wise. And then over the page, at the top of 1232, he says he respectfully agrees with these passages from his judgment, Lord Hoffman's judgment. He says, indeed, I would be inclined to go further. In my opinion, if a statutory duty does not give rise to a private right to sue for breach, the duty cannot create a duty of care that would not have been owed at common law if the statute were not there. If the policy of the statute is not consistent with the creation of a statutory liability, etc., it would exclude it. So emphasis on the policy of the statute and ultimately on whether the statutory duty which covers behaviour in question, which it does in our case, the provision of security, if that statutory duty, even if breached, which it's not here, because that claim was abandoned, but even if breached doesn't create a private law cause of action, then the common law does not come in like a white knight on its steed to save the day for the plaintiff. That's not how it works. The statute is the essential legal context. And finally, Lord Roger of Earls Ferry on page 1237, paragraph 89, where he recites the relevant statutory section and then goes over that both those paragraphs 89 and 90 matter. Because what is clear and what is picked up in Clark and Lindsell is when the relevant statutory duty is broad or wide or in the nature of a target duty, then it will not be appropriate to impose across it or over it a common law duty to compensate someone harmed as a result of its non-performance. And that is what is going on here, because Section 21 of the Airport Authority Act imposes what is classically to be described as a broad or wide duty. It is a structural duty to set up a department, to populate it with employees, and to oversee its functioning, and no more than that. And the imposition of a common law duty of care in this case cuts right across that statutory framework and imposes a liability where, quite frankly, it is not fair or just or reasonable, because this operator was able to look after itself and it was allowed to have someone manning its aeroplane when it knew, and only it knew, that that aeroplane was vulnerable to theft because it wasn't locked. Now, with the extra 15 minutes that I've used, unless I can assist the committee further, which I doubt I can right now.
Thank you very much indeed, Mr.
And I take it you're not abandoning your res ipsa loquitur challenge?
I'm not. I was carefully using the time.
No, well, it's set out in your case.
It's there.
You've seen that it was raised before the Court of Appeal.
Yes.
They didn't deal with it.
It was a ground of appeal both into the Court of Appeal and before this
Thank you.
committee, yes. And I do not abandon that. It's all there.
Thank you very much.
My lady.
Mrs. Fountain? Yeah, thank you very much indeed. Ms. Dean?
My lords, my lady, I intend, your leave, to start by addressing the facts, which I can do in brief form, I hope, because of the very extensive way with which my learned friend has dealt with them. I will then move on to this question of whether there is a private law cause of action, or whether effectively the respondent is simply stuck with what the Act says. Then deal with the existence and scope of the duty of care, and finally, if time permits, the question of res ipsa loquitur. My little disc is in front of my Lord Kerr.
Yes.
Hopefully it's going to be sufficiently strong to pick up any voices from both sides, but if I ask you to repeat
Just
yourself,
simply indicate if it isn't, and we'll bellow.
My lords, my lady, at the heart of this appeal, we say, are really three central conclusions reached by the trial judge after a trial involving, of course, exchange of witness statements and several live witnesses. Firstly, that the thief of the respondent's aircraft was unknown or unauthorized. Secondly, that how the thief accessed the secure airside apron where the aircraft was parked at about 1 o'clock in the morning was not known. And thirdly, that the respondent couldn't provide its own private security. And these findings are, we say, critical to a proper analysis of the applicable principles of law and, of course, how they're to be applied in this case. Firstly, they establish the basis for a relationship between the appellant and the respondent other than what I would call a mere broad brush public law relationship. Secondly, because they found the basis for the finding which Mr. Justice Adderley reached of proximity and of fairness, justice and reasonableness, which then of course underpins, we say, the existence and scope of the duty of care on the appellant at common law. And thirdly, because it gives the factual basis for why the maxim of res ipsa loquitur was appropriate in this case, and why the appellant was unable to displace the presumption. And the difficulty, we say, for the appellant is that there really is no justification for this court to interfere in any of those conclusions. And that being so, they support the route to liability that was taken by the trial judge and was then upheld by the Court of Appeal. And even leaving aside this court's reluctance to interfere with concurrent findings, and I have no intention of taking you through the authorities unless you wish. And the principles are, of course, well established and often repeated. These conclusions were, we say, conclusions that on the evidence and on the way in which the case was presented, they were open to the trial judge to reach. Now, the first two can really be looked at together. That the theft was by a person unknown or unauthorized, whose route of access to the secured airside was unknown. Of course, if you don't know who the thief was, and we don't, then the court couldn't have concluded with any confidence that he was authorized to be where he was. To deal with the question of the identification of the thief first. Now, I don't know whether I'm right in inferring that my learned friend is slightly stepping away in his submissions today from the written case that effectively the trial judge ought to have been driven to have accepted that it was Mr. Terreros who was the thief. Certainly doesn't seem to be being put forward with quite such vigour as it was in writing. But of course the appellant's case at trial and on appeal was that the thief was unknown. And that was because it was clearly perceived to be better for the appellant's case on the law as it understood it to be for the thief to be unknown, because the appellant's understanding of the law was that the plaintiff had to establish that there was an element of control that the authority had over the thief. The references, to the extent that your lordship need them, to how this came out in the written submissions of the authority, they are at pages 157, 158, 200, and 218. Now, of course, everyone might have had suspicions that it was Mr. Terraros, but not to the extent that the authority felt able to nail their colours to the mast and make a positive case. Of course, there'd been no criminal prosecution. There was no CCTV. There was no positive sighting of Mr. Terraros, or indeed of anybody, actually getting into the aircraft before it was stolen. And, of course, despite the fact that it was the authorities' case, that it was required, and it did, log everyone entering airside, whether they were authorised or not, then there were no logs that were available at trial that would have supported positive identification of anybody on the apron where the respondent's plane was, let alone, of course, Mr. Terraros. The only evidence that there was there were some 4 days between the last flight that Mr. Terraros had been engaged in for the respondent and the theft. And the reference to that, it comes at page 879. I don't think I need to take you to it specifically. But that was all the evidence that there was as far as Mr. Terraros. So not only would it have been verging on perverse had the trial judge or indeed the Court of Appeal attempted to point the finger at Mr. Terraros, it's hardly surprising, we say, that the appellant chose not to do that at trial.
Sorry, I mean, I understand there was no positive case that it was Mr. Terraros, but it was certainly in the Court of Appeal put forward as being a reason why the res ipsa loquitur do.
Well, in the Court of Appeal, it was in writing. Then the appellant was once again reiterating that it was that the respondent, Western Air, was not able to resile from the agreed fact that the identity of the thief was unknown. So they were effectively trying to play both sides, as it were, in the Court of Appeal. But the stance that was being taken, in writing at least, was the thief was unknown, and nobody, let alone, of course, Western Air, was able to go back on that and identify anybody specifically.
Well, I mean, so that part, I mean, I was looking at their submissions in the Court of Appeal, which clearly make a strong case that since it couldn't be excluded that it was Mr. Terraros, then the res ipsa loquitur point didn't work. Now, you say that wasn't open to them, certainly wasn't dealt with by the Court of Appeal. You say it doesn't come into it at all.
Oh, I'm sorry, I don't think I heard the last bit.
I mean, I don't understand. The sort of res ipsa loquitur point seems to have been both in the Court of Appeal and here, that you couldn't say it was res ipsa loquitur when there was a clear suspicion that, in fact, the perpetrator was an employee of Western Air. And in the submissions of the Court of Appeal, that was a strong point being made by the appellants. Now, are you saying that wasn't open to them?
Well, what you were saying on res ipsa loquitur, if I may, I'll reach that point later on in my submissions when I'm addressing that specific maxim. But I'm simply dealing at this stage with the underlying, the conclusions of fact that the trial judge had reached. And the trial judge had reached the conclusion, which of course was in the judgment, that the thief was unknown or unauthorised. Now, what I'm saying, my lord, is it is hardly surprising that the trial judge concluded that the thief was unknown when the case that was put before him by both sides was the thief is unknown. Now, the appellant was stressing the thief is unknown because of their understanding that that was going to benefit their case.
I'm not interested in that. I'm just trying to understand whether this is a point that's live. And unfortunately, we didn't get to have time to deal with it, the other side. And you're saying you'll only deal with it if you have time. And I do want some, I mean, it's page 220 to 21 of Bundle 1. We don't need to look at it now, but over lunch, where this point is clearly put in play, that it's a strong possibility that it's an employee of the Western Air. And that's put forward as being an answer to the res ipsa loquitur point. Now, by all means deal with it later, but I do want to know what the answer to that is.
That is difficult for the appellant to do in my submission, because if it's saying on the one hand, we accept and we reiterate that the thief was unknown, it's very hard to then get towards the end of their submissions and say, well, he was unknown, but it might have been X.
Ms. Deal, I do very much associate myself with what Lord Carnworth has just said. It was not proved on a balance of probabilities that it was this man.
No.
But there was a lot of evidence, and I'm looking 965 in the transcripts, but perhaps we needn't. There was a lot of evidence, particularly from the sergeant, that it could well have been him, and he was the leading suspect. And without a balance of probabilities finding, nevertheless, it may be, subject to your submissions on res ipsa loquitur,
yes,
that in particular in relation to the third requirement of res ipsa loquitur, it is enough that there was a substantial suspicion that it was him to eliminate res ipsa loquitur from coming into it.
Well, that is, and my lord, I will return to that point when I'm addressing res ipsa, but Ken, it does really come down to, it was, quite plainly we say, a tactical decision on the part of the authority that they wished to, not to enter the arena and say, this is Mr. Terreros. They were flirting with the suggestions that it might have been Mr. Terreros during the course of the trial, but never actually to engage and to point to him and say, well, this is a reason why you can't be satisfied on res ipsa. What they were doing was they were saying, he's unknown. And that was taken on board by Miss Justice Adderley, who expressly accepted that the thief was unknown. And once one reaches the point that we have a finding from the trial judge that the thief was unknown, then at that point in my submission, particularly by the point that it's come all the way up here to your lordship, it becomes very difficult for the appellant to say, well, yes, he was unknown, but also there was a suspicion that it was someone else.
Well, this submission may be informed by the point when you first raised res ipsa loquitur. If you've got the record there, yes, bundle 1, and if you've got tab 14, which is your final submissions,
yes,
to the judge on the 26th of October, and if you've got page 145, paragraph 9, we see the plaintiff also raises the claim of res ipsa loquitur. And my question to you is, had there been any reference to that principle prior to these closing submissions on the 26th of October?
I don't believe so, my lord. I will check that over lunch.
That's the impression I get too.
I don't believe so, no.
And of course, their submissions in closing submissions had preceded yours.
The dates were about 3 days apart. I don't know whether it was actually sequential exchange. I'm not
Very
sure.
well, thank you.
But I will check that, my lord. But no, I don't understand that it had been raised at a previous point.
Very well, thank you.
So yes, so say that the finding that was reached, the conclusion that was reached by Mr. Justice Adderley on the basis of the way in which the parties had both respectively put their cases to him was the thief was unknown. And the fact that the route of access to the controlled airside was unknown came from the fact that one didn't know who the thief was. Because if you don't know who it was, then you can't properly follow through the conclusion as to how they might have reached the airside, or, of course, that he or she was authorised to be there. Now, what we do know from the evidence at trial was that the only ones who were authorised at 1 o'clock in the morning, after the airport had shut, without any scheduled flights, the only ones who were authorised to be on the apron where the aircraft was parked were the Bahamas air mechanics. That came out from Tamara Winder-Sears, who was one of the security guards there. It was some references are paragraph 6 on page 300, and then in her oral evidence at page 908 of the transcript. So there's no suggestion, of course, that any of the Bahamas air mechanics were the ones who were responsible for stealing the plane. But what we do know is that she says there's only one particular group of persons who would access the gate that we would allow to access that gate. So the point is out there from the authority that the only people that were, in fact, authorised to come through the gate that she was being manned that got through to the apron where the aircraft was parked were Bahamas air mechanics who, of course, weren't in the frame, if I can put it that way at all. So anyone accessing that area should, on the authorities' own evidence and on the basis of their own procedures, have been logged, or indeed turned away and then logged. And the references to that are coming from the two authority witnesses in particular, Milo Butler III and Osborne Ferguson. The references for the nature are paragraph 12 on 317, paragraph 14 on 318, and paragraph 17 on 340. And because none of the logs, the diaries identifying either who accessed the secure airside or who had tried to access and been turned away were disclosed, then there was no way that the court could properly have identified who, if anyone, was legitimately there at the time, let alone, of course, who was there without legitimacy, and who might have set the red flags waving, as it were. And this is important because the authority was the gatekeeper. It was the gatekeeper of the secured airside, and it was the only gatekeeper of the secured airside. It had the responsibility to ensure that only the people airside in the middle of the night were people who were meant to be there. Quite aside, of course, from the duty of care that we say that the authority owed to Western Air, it owed that duty more generally because it was the airport authority. If there were unauthorised people on the apron, then something had gone wrong. And if the authority didn't know who was on the apron at 1 o'clock in the morning, then something had gone wrong. And no one other than the appellant could have put that evidence before the trial judge. It didn't do so. And of course it can't, we say, ask your lordships or your lordship to accept now that the conclusions of the trial judge that the thief was unknown and that the route of access that was taken to the secure airside were conclusions that were not open to him. Still less, of course, to suggest that they unequivocally lean in an opposite direction to the ones that Mr. Justice Adderley took. The third conclusion concerns Western Air and its own security. Now, I appreciate your lordships have already asked questions of my own friend on this. In the Court of Appeal, the appellant suggested that, in fact, there'd been no evidence regarding an inability for the private operators or the commercial operators to have their own private security. I think it's now accepted that at least there was via the evidence of Mr. Roll. In his witness statement, which was, it's at page 280 and at paragraph 12, he sets out, and my learned friend has already taken you to that, his understanding on the basis of what, by the time of the theft, was a 7-year relationship, a 7-year period when Western Air had been using this airport, that security was for the authority. It wasn't for the individual operators. Now, neither he nor Mr. Seifert, who was also called for Western Air, were cross-examined at all. So that paragraph in Mr. Roll's witness statement, making a public assertion that it was understood from general conversations that had been had over the years that security was for the airport and not for the operators, went entirely unchallenged.
I mean, I find this all very odd. I mean, both parties have some duties in the respect. One expects the airport authority has a responsibility to keep the airport secure and make sure it has a perimeter fence. And
layers of security, I think it's put away.
Whereas presumably Western Air has normal responsibility, if it owns a plane, to make sure it takes reasonable steps to ensure it's secure. Now, the balance between those two obviously may be a matter of debate, but I mean, it seems absurd to suggest that one has that it's exclusive to one or the other.
Well, there's only one party that can control who gets outside.
Yeah, well, I understand that.
Yeah.
That's your case.
Yeah. But no, there is the additional responsibility on the operators to ensure, particularly when they leave their planes at the end of the day, when there are no more scheduled flights and the airport is closed, which of course is the case here, to ensure that their aircraft are left secured. Now, there is a question, which of course came up and was addressed at length in the evidence, about what secured meant in the context of this aircraft. And much was made, and to an extent, a lesser extent today, it's being made about, well, this aircraft was simply not left secured. The evidence in my submission was this aircraft was left as secured as an aircraft of this type could be. The obligation to remove the stairs is obviously impractical when the evidence is that the stairs are built into the door. On this standard, once you pull it down and the stairs built in, you can't remove them. And when the evidence is that it was left locked in the position that the manufacturers say is locked. Now, that might well mean that it could nonetheless be opened by somebody because there's not a lock and a key, and a number of questions were raised. Well, can you lock it? No, you can't lock it. It doesn't have a lock. It's not lock in the sense of a house might be locked, but it is left secured as far as an aircraft of this kind can be secured when it's left under the, effectively, as the judge accepted, under the control of the, or under the care of the airport. So yes, my lord, we entirely accept that there are layers of security, but ultimately it's the authority that is the first and last line of defence as to who is authorised to be on the apron and what steps are made to ensure that only those who are authorised to be on the apron are there. And as the evidence came out from Ms. Windaseers, the only people who were authorised to be there were the Bahamas air mechanics, and none of them were involved in this, then comes down, as far as the respondent is concerned, to something had gone wrong.
Ms. Deal, before we leave the issue about the evidence in relation to private security, the case against you is that your predecessor, no doubt unintentionally, lulled the trial judge when he read final written submissions into thinking that just as Mr. Roll had said what we know he said, so equally the defendant's evidence was similar. And in particular, Mr. Ferguson had said the same thing. And we've been looking at that at 135. Perhaps we don't need to look at it again. But the case against you is that that was quite the wrong way round. And if the judge had been properly addressed about the evidence, he couldn't simply have said, pat, the evidence is that private security wasn't allowed, because there was some significant evidence that it was. Well,
Mr. Ferguson and Mr. Butler were the ones who gave evidence for the authority on this. Mr. Ferguson had not started until 2008, and Mr. Butler had not started until 2010. So neither of them were giving, nor could conceivably have given evidence as to what the position was at the time of the theft. So they couldn't, there wasn't, in fact, we say, any inconsistency between what Mr. Roll was saying was his understanding formed over the 7 years that Western Air had been using the authorities' facilities at the airport, and what was being said by Mr. Ferguson and Mr. Butler. And if one looks at what Mr. Ferguson and Mr. Butler were actually saying, now I appreciate we've already been taken to that briefly, Mr. Ferguson, and this is at 981 where it starts, line 16, question, would you as Director of Security, and I guess in consultation with the authority, allow Western Air to have another security team come and act as security for their airplanes? Now this is a trial in 2012. He's not being asked, well, what would the position have been at the time that the aircraft was stolen? He's being asked present tense, and his response has to be looked at in my submission in that light. If they make an application for it, it would be reviewed, and if they wish to do so, we will try to facilitate. Now, I think it was my Lord Carnworth who said, well, that doesn't actually mean that it would be permitted. And absolutely right. What has the limitations of the evidence and the question that it's asked and the answer that it that comes back? Does the airport authority, under your direction, require persons parked on, I think I-5 is apron 5, to have their own private security for their planes? No, we have nothing such as private security for the plane. Now, that, and I would, to the extent that my own friend and I are indulging in speculation, I would agree that that is probably where the point that was raised in the written submission comes from, because the question is, do you require people to have their own private security? And the answer is no, we have nothing such as private security for the plane. But in fact, in my submission looked at properly and within the limits of what was being asked and what was being answered, there isn't any inconsistency between that and what Mr. Roll's understanding was. The high point is Mr. Butler. Mr. Butler was asked the question that starts on 1007.
Yes.
Line 9. Now, as the airport, and from your review of the file, did any airline, so past tense, and in probably particular Western Air, ever ask airport authority to allow the security? When I say security, like security personnel or anything other that they may need to security their aircraft on apron 5, I will say this, ma'am, from the review in this file in this instance, I don't see that. So that is as far as it goes if one is looking back at the position which is covered in the file, however far that is, but at least it is a past tense question referring back to a previous situation. And again, I'd say there is no inconsistency between Mr. Butler saying, well, there's no record of anyone having made a request for their security, and Mr. Roll saying, effectively, it was understood that there was no point in asking because it wouldn't be allowed, because security
but you
was in...
I mean, we read it before. Perhaps you can be forgiven for not reading it again, but you have stopped at the bit.
Oh, no, I'm just about to go on to that.
He goes on to say, I worked for an airline, actually, once, and we did ask this airport authority for private security, and we were granted it.
That's exactly the point I'm about to go on to, my lord.
Very well.
What he's talking about is a role that he held prior to 2010. And we know prior to 2010 because 2010 is when he moves to the authority. But there's no details there about dates. We know that the request, to the extent that it may have been made, isn't included in the file because Mr. Butler has just that moment before confirmed that when he's looked through the file, then he can't see any request for security being made by any operator. Spirit, of course, is a US airline, it's not Bahamian. So he's not saying when the request is made. He's not even talking about which airport, because, of course, the airport authority has responsibility for more than one airport. And he's not talking about the circumstances which might have given rise to this. And if I could take your lordships to...
Why don't you do that? Why don't you do that after lunch, Ms. Deere?
If I can just take you to his one reference,
right.
and then at that point I will
Right.
pause for breath. It's at page 705, which is the Airport Authority Security Programme, AASP. And it's the section on security of aircraft, part 14. You have been referred to this previously by my learned friend. But if I can take you to the last paragraph of 14.2, protection on the ground.
Sorry, which bundle is this in?
This is bundle 3.2, my lord.
Thank you.
if a request is made by an airline operator for special measures to be implemented by the airport authority, the Director of Security will make an assessment of the threat. After an evaluation and consultation, he will then provide the necessary resources to meet the threat level. So, to the extent that, it is set out in the procedures that there is facility for asking for additional protection in the event that there is a threat. And at that point, there's going to be a consideration by the Director of Security and a consultation, and he will then provide the necessary resources to meet the threat level. So, of course, what we don't have is any information, any detail by Mr. Butler that enables one to tie this together, but that is the high point of the case on that regard.
Right.
I shall resume at 2.
You shall. So will we.